Hello everyone, we're about ready to start. Welcome to our ICANN 61 update webinar. My name's Ashley Roberts and I'm a senior manager here at Validatus. Over the course of the next 30 minutes, we're going to cover the key topics that came out of the recent ICANN meeting in Puerto Rico. We're going to begin with our SVP for North America, Jeff Newman, who's going to talk us through the current status of the new gTLD Subsequent Procedures PDP, which Jeff is also the co-chair of. Then we're going to hand over to our Head of Legal Policy, Susan Payne, to explain how the work of the Rights Protection Mechanisms Review PDP is going. Finally, we're going to move on to the topic which dominated the ICANN meeting, and that's GDPR and its effect on the future of the WHOIS. Jeff and Susan will both guide you through what developed in Puerto Rico on that front and what has happened since. Before we begin, just a small bit of housekeeping. If you have any questions on anything that we discuss, please drop them into the questions panel that you should see on your screen, and then we'll endeavour to answer the questions at the end of the webinar. Anything that we don't have time to answer, then we'll respond by email after the webinar. Equally, if you have any technical issues with connection during the course of the webinar, please send an email to info@validatus.com and we'll answer that question as well. So without much ado, I'm going to hand over to Jeff for his update on the Subsequent Procedures PDP. Jeff?
Yes, thank you, Ashley, and good morning, afternoon, evening to everyone. As Ashley said, although the topic of WHOIS and the general data protection regulations dominated much of ICANN 61, there was also a good amount of time spent on covering the next round of new gTLDs, which we call in the ICANN world the subsequent procedures. And in the next few slides, what you'll see are timelines that were discussed, all leading up to the million-dollar question of when will there be another round of new gTLDs. One of the important processes that is taking place now is the policy development process on subsequent procedures, really tasked with reviewing the 2012 round, which it's hard to believe that it was over 6 years ago that the round opened up, and what was good about it, what was bad about it, what can be improved, while also answering the question, do we really need new additional gTLDs? So this policy development process has been working for the past year, actually a couple of years, and hopes to have its initial report out for public comment in late April this year, as you can see on the slide in front of you. That will go out for comment for approximately 45 days, and hopefully the report will be discussed at ICANN 62 in Panama. That report will cover what's called work tracks 1 through 4, which are questions dealing with everything from should there be additional new gTLDs? If we do, should it be in a round? Should it be as a first come, first serve? Should there be a brand only round? What should the fees be for this next round? To what should the contract for new registries look like? And should there be a more robust process for objecting to new gTLDs? Should there be consideration given to how many top-level domains someone applies for? A host of lots of questions that the work tracks have been talking about for the past couple of years. As I said, that report from work tracks 1 through 4 should be out in late April this year, and with the hopes of beginning work on a final report in July of 2018. If we go on to the next slide, there is a fifth work track, and this work track deals exclusively with the topic of geographic names at the top level. Because of the great interest in this topic from a number of different communities or stakeholder groups within the ICANN community, it was decided probably about 6 months ago to separate the work out of geographic names into a separate work track that had leadership from each of the supporting organizations and advisory committees. So the leadership of this task force, or this work track, consists of someone from the GNSO, the Generic Name Supporting Organization, a person from the Country Code Name Supporting Organization, someone from the Governmental Advisory Committee, and a person from the At-Large Advisory Committee. This work track, because it started a little bit later than the others, has a little bit longer of a timeline, as you can see in front of you. But because it is only focused on geographic names at the top level, we expect that by Q1 of 2019 to have the two different efforts, work tracks 1 through 4, and the work for work track 5 to be joined at that period of time, as we can see in the next slide. There we go. So what the next steps are, and then I'll talk a little bit more in detail about some of the substance, is that the hope is to submit a final report from the work tracks 1 through 4 in Q4 of, or probably by the end of this year. And then in Q1 of next year, once the council receives both the recommendations from work tracks 1 through 4, as well as the recommendations from the geographic names issue, work track 5, to consider those and to adopt those and send those to the ICANN board somewhere in Q2 of 2019. The board would then, and this, just so you look at this slide, this is kind of a best case scenario, or instead of using the word best case scenario, is a scenario that really is probably the quickest that we could see the launch of the next round. If the ICANN board adopts those in Q2 or Q3 2019, we could see a guidebook in 2020 and a process beginning, application process in Q1 2021. It's really difficult to predict with any certainty a timeline because of the number of steps that have to happen before the program starts. And this is really just the policy and implementation side of the new gTLD program. There is a lot of work for ICANN staff and the organization to do in preparation for that program. And so one of the topics that was heavily discussed in at ICANN 61 was the notion of getting some budget for the preparation of the next round, even though it may be several years away. There are a number of steps that the ICANN organization needs to take in order to be in a position to launch that, even if a few years away in 2021. So things like ensuring that there is an application system to input applications, things like making sure there are evaluators and a process for objecting to applications, and all of that stuff that happens behind the scenes needs to really start the planning process now if they are to launch in even in 2021. So just to kind of summarize what you're going to see in April, so towards the end of April when the initial report is released, there will be a number of recommendations on what can be done better in the future rounds, plus a number of questions out to the community where there are several different paths that can be taken for a particular issue. And so it's going to be very important. And of course, Valideus and Cum Laude are going to be working with each of our clients to discuss the ramifications of those recommendations so that we can include your comments during the comment period. But it's going to be important to answer or to at least provide input on things like, should there be a brand only round? If so, should that be before any other rounds? Should there be a round for geographic top level domains? Should there be a limit in the number of applications that one could be able to submit? How do we avoid things like speculation? And of course, things like if there is going to be a next round, what should the cost of those applications be in order to ensure that for those brands that do want a new top-level domain, that it's not cost prohibitive, but at the same time, how do we ensure that there's not speculation that goes on from non-brand owners or from those that really just want to warehouse those top-level domains? So lots of important questions coming down the path, and we will be there to help everyone to be in a position to respond to this. And with that, there's another very important aspect of the future rounds, and I will turn it over to Susan to talk specifically about the rights protection mechanisms and what trademark owners can do and what they'll be able to do to protect themselves during the next round.
Thank you very much, Jeff. Yes, so I'm going to just talk about the second sort of big PDP that we wanted to cover today, which is the one on the review of the rights protection mechanisms. And where we are at the moment in the process is that it's being dealt with in two phases, and so we're still after 2 years, we're still in phase one, which is dealing with the rights protection mechanisms, or RPMs, that were introduced for the new gTLD program specifically. And then phase two, which is going to deal with the UDRP, will come later. In terms of what happened during the ICANN meeting in particular, and what we're currently working on within phase one, that it's kind of two-part. There's a piece of work underway, and has been underway for a little while, in relation to the Sunrise and the trademark claims, and those are the two mechanisms that flow off the trademark clearinghouse, and that is effectively a data gathering exercise. So ICANN has been issued an RFP to try and identify a survey provider who will be seeking to gather data in the form of surveys of various different interest groups, which will include registries, registrars, IP owners, and other types of registrant. And that RFP closed in at the beginning of March, and so ICANN staff are now working to actually identify and appoint a survey provider. But once the survey provider is in place, there'll be a certain amount of work to be done behind the scenes by the working group in order to help shape the survey and to try to ensure that it elicits usable data. And so that will be something that we'll probably talk about again after the next ICANN meeting, for example. It's almost certain that it's hoped that by that point we might actually have some actual input from those surveys. And whilst that work is underway, the working group turned its attention instead to the URS, or Uniform Rapid Suspension, which is the dispute resolution process that was introduced to sit alongside the UDRP for new gTLDs. And in relation to that, the working group has spent some time reviewing the charter questions that we were tasked with answering, and trying to kind of make sense of them and determine how most appropriately to consider them. And then we broke into 3 sub-teams to try to identify data requirements and possible sources of information to help answer those questions. So in Puerto Rico, the 3 sub-teams reported on their progress. But I would say the timing wasn't particularly ideal, as they were all really only a couple of weeks into their task, and none of those 3 subgroups had actually finished their work. So although for none of them it's a particularly lengthy task, it was very much a kind of an update on work in progress. And then, in my opinion, the most useful session in Puerto Rico for the work of the working group was a session on the Thursday morning, which was with the 3 URS providers, where they sort of talked through together with their processes, and they identified areas in the URS rules which require certain steps to be taken, and how each of the 3 of them actually do that. And they put some useful charts up that showed, how they operated, and the similarities and maybe slight differences that existed. And it was a really productive session, and one that it would have been very, very beneficial for us actually to have done much earlier in the stage, really at an earlier stage in the process, because we answered, or rather they answered, a number of the questions that some members of the working group had really been speculating on. And we, to some extent, wasted a certain amount of time speculating on things that we didn't need to be worrying about. So in terms of kind of timeline and next steps, the working group has a new timeline, which was presented to the GNSO Council in Puerto Rico. And that envisages that phase 1 is going to issue its initial draft report in Q1 2019. And that would mean that phase 2 on the UDRP might start somewhere around mid-2019. And that's a slippage again from the previous timeline rather, a slippage of probably about 9 months or so. And even despite that, I would say that I think it's optimistic with the speed of work on the working group and the way in which its work is quite contentious and issues are frequently reopened and sort of relitigated. It seems to me that timeline probably is not a really accurate one. It's something that is undoubtedly achievable, but it would only really be achievable with kind of better control on the work of the working group and better management of the working group, frankly. And as a result, that was one of the subjects that was discussed within the GNSO Council when they held a strategic session on how to make the PDP processes more efficient and more effective. And there was a sort of quite an interesting brainstorming session talking about some of the issues and what might be done to improve them. And it was also one of the factors that gave rise to a suggestion from John McElwain, who's a US IP attorney and is a former chair from INTA's Internet Committee, who was suggesting that it might be sensible to move the URS from phase 1 and into phase 2, because in fact there are a number of synergies with UDRP. And the URS doesn't really impact a new application round of gTLDs at the application stage, and also because the GDPR, which we'll be talking about shortly, actually the rules require a lot of use of data from the WHOIS under the URS and the UDRP, and so there's some uncertainty in the process as a result of the GDPR. And so really, I in terms of why this is important, well, I mean, I think anyone who has brands obviously is keen to ensure that there are adequate rights protection mechanisms in place, and so that's obviously of interest to many brand owners. As mentioned, the RPM's recommendations are meant to be taken on board by subsequent procedures, so this work on the RPMs potentially impacts on the timing for new gTLDs, and that's relevant for anyone who's interested in applying. And finally, as has been anticipated, the discussion about the URS has proved to be a preview of many of the arguments that are going to be run around the UDRP because of the somewhat similarities between the two dispute processes. And so if the UDRP is a dispute mechanism that's very important to you and that you want to safeguard, it's certainly something to keep an eye on, and you might want to even actively engage. So that's just a quick rundown of what's currently going on with the RPM's review. And now I'm going to hand it back to Jeff, and we're going to talk in a little bit more detail about the GDPR and what that means for WHOIS.
Thanks, Susan. And so as Ashley said kind of at the outset, really much of the time during ICANN 61 was spent talking about the General Data Protection Regulations, GDPR, that although they were passed several years ago, I think in 2016, they enforcement of those regulations comes into effect on May 25th this year, so less than 2 months away at this point. And so although there is and has been a policy development process within ICANN talking about WHOIS issues for a number of years now, and in fact have been multiple policy development processes in the last 2 decades, the work on GDPR, because there's an immediate need to respond, has been taking place separate and apart from that policy development process. But at the end, we'll talk about how it does relate back to that process. So, I'm sure everyone on this call knows that the WHOIS database is a globally distributed repository of registration data, and that includes things like contact information and other information that ICANN considers and the community considers necessary for, and I'm reading from their latest letter, for the secure, stable, and resilient operation of the internet. And so many of the developments I'm going to talk about now weren't just within ICANN 61, but because this is a consistent and constant moving topic, have happened even in the past week or two since we've gotten back from Puerto Rico. So prior to ICANN 61, ICANN released what they called a proposed interim solution of how they believe registries and registrars could comply with the GDPR, but also recognize the legitimate purpose for which many, including law enforcement, intellectual property attorneys, and others, use WHOIS information in order to protect the security and stability and resiliency of the internet. That solution was called the calzone method or cookbook, that basically put together a number of elements that were suggested by different parts of the ICANN community. And so much of ICANN 61 was devoted to talking about those that interim model, and whether that model was good, what was good about it, bad about it, and what needed to change, and recognizing what we had anticipated, or what the ICANN community would anticipate data protection authorities to do in response to that proposal. The big difficulty about the dealing with GDPR is that none of us, whether it's any law firm or anyone in the domain industry, knows for a fact what the data protection authorities will do once May 25th comes around. And in fact, the data protection authorities don't know what they're going to do, because at that point, there's supposed to be a privacy board that comes into effect. And so prior to that policy board coming into effect, the data protection authorities really aren't in a position to make any comments on how the GDPR will be implemented, or I should say enforced, because they simply don't know. So given the uncertainty, what the ICANN proposed interim solution has in mind is a couple different elements. Number one is a recognition that the way we have WHOIS today will change. That today, everything is made available to everyone. All the contact information is made available to everyone, both in a query by query, just doing a search of one name by one name format, and also by many in what's called bulk data format. So if you are an intellectual property attorney, you may use a service like we offer, or that Domain Tools or others offer, where you would like to see every name owned by a particular registrant to help you establish a pattern of abuse if they have multiple names registered of multiple trademarks. So that is the way it is today. Come May 25th, there's a recognition that only certain information will be able to be made public to everyone, regardless of the need for that information. And other information will only be available to those that are deemed to have a legitimate public interest in seeing that data. Now, the legitimate public interest has been open for debate. Governments, through the Governmental Advisory Committee, in their communique, have stated that law enforcement, intellectual property attorneys, those enforcing consumer laws, and others have a legitimate public interest in open access to WHOIS information, while others are making an argument that only a subset of those have a legitimate interest. So that is still an area that is being talked about as to who would have access to that data, and what that's called in the ICANN model is which entities could be accredited to get that data. And Susan will talk a little bit about one proposal for accreditation that's been discussed, and what data those accredited organizations would have, and how they would have access to that data. So the areas of most contention at this point are the GDPR technically only applies to the European Union and the member states. However, the ICANN model applies globally. So regardless of whether a registrant is located in Europe or whether a registrar is located in Europe. What the ICANN model is saying is that the same model of accreditation and tiered access should be applied globally, regardless of the location of the registrant or the registrar. The second area of contention is that technically the GDPR only applies to natural persons, meaning individuals, to have their private, personally identifiable information protected. But ICANN has their model applies the solution globally to both natural and legal persons or corporations. And this is primarily, at least according to ICANN, because of a recognition that even if there is a domain registration by a corporation, there still could be personally identifiable information in the WHOIS records for those corporations. So for example, and we don't do this, but some companies may have list, let's say, jeff.newman at cumlaude.com as their administrator for the domain registration. Again, we don't do that. We don't recommend that. We recommend something like domain administrator at whatever company or something like that. But there are some companies that do have personally identifiable information in their WHOIS. And rather than trying to come up with a mechanism of distinguishing between natural and legal persons, ICANN's recommendation is to treat them all the same. A third area of contention is, does the personally identifiable information also include, or should it also include, the registrant email address? Intellectual property attorneys, law enforcement, and others have made the argument that the registrant email address is probably one of the most vital pieces of information provided through the WHOIS database in order to contact the registrant to, if there's any abuse going on with the domain, or if there's cyber squatting, etc. And without that registrant email address, there's no effective way to contact the registrant about the registration, though ICANN has suggested in their interim model that an anonymous web form or an anonymous link to the email address could be created to not reveal the personally identifiable information, but also allow a mechanism to relay information to the registrant. And of course, the $5 million question of who's going to have access to that information, to all of the information, and what data will they have access to, and how will they be able to access that is still a topic being discussed with a relatively short amount of time left. So I'm going to turn it over to Susan to talk about one particular model that's been proposed. So Susan, please.
Thanks, Jeff. And that leads in perfectly to this this proposed accreditation model that's been put forward by a group of IP and business interests within the ICANN community. And they included Microsoft, Facebook, and Time Warner, and some service providers who worked on this model during the Puerto Rico meeting and socialized it towards the latter half of the meeting. And this was a recognition that really ICANN's interim model wasn't really addressing the question of access. So they were talking very much about what data should be public and what should be behind a wall, effectively, but not how you got through that wall. There should be gated access, but not what that gated access should be. And so, in an endeavour to get the conversation moving and ensure that there might still be a usable WHOIS system in the future for those sort of IP and law enforcement interests, this group put together a proposed accreditation model that they, as I say, that they've been socializing. It's very much a moving piece. They've been trying to take into account feedback from other parts of the ICANN community and sort of refine it as they go along. And so version 3 of that model has just been issued, and that's in the course of really just a couple of weeks since the first version was circulated. And it's a proposed model that's making some concrete proposals on some key aspects, really. So it would be, who would the types of eligible entities be, for what purposes and what data would they get, how they would be accredited, and what kind of credentials they would have to demonstrate in order to be accredited. how this accreditation model would operate, and some terms of use of it. And in terms of just some of those, I won't talk about all of them in detail. I mean, it's now become a very detailed proposal, and it is something that you can find quite readily on the data protection page that ICANN is operating on its website. But they're proposing that this would cover 3 different groups. So cybersecurity and OPSEC investigators, intellectual property interests, which might include brand owners and those who act for them, so sort of external lawyers. And then there's also what they call a placeholder for law enforcement agencies and other governmental agencies. And I think this latter one is only really a placeholder, because it is rather anticipated that appropriate government representatives will want to work on this. And it's also recognised that of those 3 groups, the ICANN interim model does give sort of greater recognition to the need of access of law enforcement than it does to the other 2 groups. And so there was a definite interest in trying to ensure that IP interests and brand enforcement and security enforcement interests were not left behind in this process. And in terms of accreditation, as I say, the model talks about the various types of credentials that different parties might have to present in order to become accredited. So, for example, if it was IP interest, then you might have to give evidence of your ownership of the IP right, and if you were an external legal advisor, then you'd need some appropriate letters of authority from the relevant brand owner that you were working for to establish that you were actually being instructed by them to act on their behalf. And obviously there's real concern about ensuring that any accreditation model would be sort of compliant and would hit the relevant balance that the GDPR envisages. And so it also envisages that applicants would have to make certain commitments, including to agree to only use the data for legitimate and lawful purposes, that they would have to agree to comply with the GDPR and with the model terms of service in order to prevent abuse of the data, and that they could be subject to de-accreditation if they breach any of this, and there could be penalties as well under the GDPR. Because obviously, you know, if you give access to this data, you want to be sure that it's not going to be misused. And in terms of the proposed model, that's really proposed to be a kind of centralized system that someone will operate to do the accreditation piece. And that once you have credentials as an individual wanting access or as a business wanting access, that there'd be a federated model to access the WHOIS. So you would go into any one of the WHOIS systems that's being operated and kind of type in your credentials, and then provided that they come up as valid, you would then get in through the gate and be able to get access to the data. Another important factor would be this idea that it's been felt that you should have annual reaccreditation to ensure that obviously you're being rechecked for appropriateness on a regular basis. And since someone is going to have to pick up the cost of this, it's recognised that there would need to be a fee to be paid, and that fee would be paid by the applicants for accreditation and would be to cover the cost of running the system. And just really briefly, in terms of next steps, it's, as I said, and as Jeff's been saying, it's all still very much a movable piece. ICANN has sent its interim model, the cookbook, to the Article 29 Working Party and to various European data protection authorities just sort of very recently. And we understand that there's a meeting tomorrow, and ICANN is very keen to get some feedback on the interim model. In particular, you know, is this interim model compliant with the GDPR? And they're also asking for a moratorium on enforcement, since even on the most optimistic of timelines, ICANN doesn't see this all being in place before December, and most people will have spotted that December is sometime after May, which is when the GDPR becomes enforceable. ICANN hasn't sent the accreditation model to those entities. In Puerto Rico, Joran Marby said that he didn't think it was appropriate to do so because it wasn't agreed by all parts of the community. And I must say that seemed a little rich, I think, coming from him, given that his own model, the interim model, is hardly something that's been agreed by the whole community, even if, you know, various members of the community have been wading in and giving input. And so I think there's almost certainly a side exercise going on, as I said, about socializing and getting input on this accreditation model. And a number of IP interests, I think, are also being encouraged to contact data protection authorities themselves and try to get their thoughts on access by IP interests and the like, and their thoughts on the accreditation model, and to try and help move that along, because we're coming up to May, and the real risk of some of the important data fields going dark and there not being a process in place for accessing them. So that was all I was going to say for now. As I said, it's a very movable piece, and it's obviously happening very fast because of this urgent deadline. So I'll pass back to Ashley.
Right, thank you, Susan, and thank you, Jeff. We're a little bit over time, but I want to try and get to one of the questions that we've got in, and it relates to GDPR and something that Susan was just alluding to. So the question is, what is going to happen come the end of May if the GDPR work hasn't been sorted out? Jeff or Susan, would one of you like to take that one?
Well, I'm happy to give it a go, and I'm sure Jeff can leap in as well. I think realistically, unless there's some support being given by the Article 29 group to ICANN, either that they think the interim model is looking good, or that they are going to recognise that the significant work that's underway is kind of good enough, and that they'll give them a kind of moratorium on enforcement. If that doesn't happen, I think realistically what we're going to see is that the registries and registrars who are going to find themselves subject to the GDPR are likely to effectively sort of do their own thing. So we'll get, at least initially, a fragmented approach. It's also likely that they will probably bear very much in mind the models that have been discussed by the community over the last few months, and the ICANN model in particular, and so they probably will be turning off those particular data fields that they feel contain personal information, whilst keeping some data fields still live, the ones that are less personal. But I think we'll also then see each of them individually adopting their own kind of case-by-case decision-making on who they give access to in terms of the non-personal element, sorry, the non-public elements. So it's an unsatisfactory solution, or unsatisfactory situation, that we could have a period of some few months, hopefully not longer than that, where there isn't a standard approach.
Thanks, Susan. Okay, we are a bit over time now, so for the remaining questions that we received, we're going to reply to those via email in the next day or two. Thank you everyone for joining this webinar. I hope you all found it helpful. You should receive automatically receive a recording of the webinar within the next 24 hours. If you don't get that and you would like a copy, then please send us an email to info@valideus.com. That's info@valideus.com, and we can send that recording to you by email. So I'll draw a line under it there. Thank you very much for joining us, and I hope you all enjoy the rest of your day. Thanks. Bye.